case of Freedom Forever and others versus Union of India, we are representing the Freedom Forever as well as and others, your lordships. Council 1 will be dealing with issues number 1 and 2. Council 2 will be dealing with issues number 3, and this is our team researcher. If your lordships are well aware with the facts of the case, council requests permission to move with the issues. The first issue being whether the right to dissent guaranteed under Article 19(1) Clause A is violated. It is humbly submitted before the Honorable Court of India that the right to dissent guaranteed under Article 19(1) Clause A has been violated. The aim of this particular statute is to curb terrorism, but while doing so, it has to ensure that it does not violate any constitutional mandate. But TAPA has blatantly violated the golden triangle of the Constitution, your lordships, and does not satisfy the test of proportionality. If your lordships may permit, the council would want to cite a case. Council seeks permission to submit their team compendium. In the flag number 5, your lordships, available in our compendium, in the case of K.S. Puttaswamy and another versus Union of India, it states that to check arbitrariness, there's a threefold classification. The first being there must be a presence of law. Second, a legitimate aim. Third one, there should be proportionality, which means it guarantees a fair relationship between the objects and the ways sought to achieve them. Fourth one is that there must be procedural guarantees to ensure all of this, your lordships. The council will be laying down certain points as to how the legislation is not proportional. The first being Section 15 of TAPA.
Just one.
Yes, your lordships.
So here, who are the petitioners?
The petitioners are
Who are the petitioners?
The petitioners are Freedom Forever, Freedom Forever,
That
as well as
non-citizens.
No, your lordships, they are the citizens.
They are
of the
citizens of the country or non-citizens?
They're the citizens of the country of India, your lordships.
Citizens of the country.
If your lordships permit, council would request to move on with the further arguments. Section 15 of TAPA, your lordships, states a line which says with intent to strike terror or likely to strike terror in people. But the Act fails to define the very word terror, your lordships, and its overbroad analysis can result in malicious intent. Now, it is a well-known fact that penal statutes must have a strict interpretation, which has not been done in this particular section, your lordships, with the word terror, your lordships. It has an overbroad analysis. Now, moving on to the second point, your lordships, the council will be laying down certain rights given in this Act, your lordships, in the 2019 amendment. That is, the right to make application to the central government for removal of names from the 4th schedule. The second right is the right to have the application decided in 45 days. The third right is the right to apply for review if the application is rejected to the review committee. Fourth right is the right to ensure review committee acts in consonance with the principles of judicial review. Now, these are the rights given under this Act, your lordships. But the government has sneakily classified the individuals into two types, your lordships, which is hidden in the provisions. Now, the two types they've classified the individuals into is the first one is where the individuals whom the central government believes to be involved in terrorist acts, which is given in Section 35 of TAPA, your lordships. And if the government believes you to be involved in terrorism, then your names are published in the 4th schedule. And all these rights which I just mentioned are available to them. The council's concern is not with these people, but the council's concern is with the class of people, or the second class of people, that is, individuals whose charges have been involved in terrorism is sanctioned by the government, but not published in the 4th schedule. That is Section 45. Now, these rights or mechanisms are not available to them, your lordships, and the council fails to understand the intelligible differentia behind classification of individuals itself into two types. And it goes against the Anwar Ali Sarkar case given in flag number 31 of our compendium, where one gets no rights and a lengthy trial process, your lordships. And there is clarity behind the classification and no guidelines for the same, your lordships. In the case of E.P. Royappa versus State of Tamil Nadu, available in Section 35 of our compendium, it states that equality is antithetic to arbitrariness. Now, the unequal classification of individuals into two categories thus makes it violative of Article 14, and the lengthy trial which these individuals are subjected to makes it violative of Article 21, your lordships, lordships, and they do not have a recourse for speedy trial, which is guaranteed under the constitution itself, your lordships. And now TAPA has given rise to a situation where the government itself has the discretionary power whether to publish a group of individuals in the fourth schedule or not publish the individuals in the fourth schedule, your lordships. Now, it is known, your lordships, in the case of Shreya Singhal versus Union of India, available in Flag 33 of our compendium, it is known that vagueness may invalidate a criminal law for two independent reasons. Now, the two independent reasons are, law must give a man of reasonable intelligence the opportunity to know what is prohibited and what is not. The second, to avoid arbitrariness and discrimination, the law must provide explicit standards, which has not done by this act, your lordships. And the council will be laying down how it is vague also. One in section 15 and one in the definition of unlawful activities. Now, unlawful activities prohibits free speech by threat of punishment and by casting a wide net. And the overbroad language and vagueness of the section has a tendency to rope in mere criticism of the government policies and actions of the day without any effect to public order or security, sovereignty and integrity of the country, your lordships. Its indiscriminate use by the authorities against those critical of the government has made it impossible in securing bail under section 43D5 of the Act, your lordships. And in the case of NIA versus Zahur Ahmed Shah Watali, which is given in Flag 39 of our compendium, it is said that it is not permissible for the courts to even engage in a detailed analysis of the prosecution of the case while considering bail under TAPA, your lordships. And to weigh whether...
Madam,
Yes, your lordship.
what's your difficulty you have in 43D5?
43D5, your lordships, where the individuals are classified and their names are not published in the fourth schedule, they have a lengthy trial process, your lordships, and since it's a cognizable offence, even the facts, your lordship, those individuals weren't given bail at all. There were many innocent. NIA had run an investigation, a secret investigation, where many individuals were brought in, your lordships, just for a mere belief of the government. And these people, for them, the bail provisions were rejected in all three courts, your lordships. And that is my issue with 43D5, your lordships, where one class of individuals have been blatantly separated from the society, your lordships.
Which is that class of individuals who's separated under
The
43D5?
Your lordships, that is the individuals whose trials have been involved in terrorism is sanctioned by the government as mentioned in section 45. They do not have any rights or mechanisms available for those citizens which is mentioned in section 35 of the Act, your lordships.
All right.
Moving on with the further arguments, your lordships. Now, section 43D5 and section 2O of TAPA, your lordships, brings a chilling effect on the freedom of speech and expression. Now, chilling effect is stifling legitimate speech and expression by its excessive broad analysis, and it is unwanted prohibition of one's free speech for the fear of criminal sanction. In the case of S. Kushbu versus Kanyamal, in Flag 34 of our compendium, your lordships, it has been stated that law should be construed in a manner so as to avoid chilling effect over freedom of speech and expression, which is done in section 43D5 and section 2 clause O of this Act, your lordships. And in the case of S. Rangarajan versus P. Jagjeevan Ram, your lordships, which is mentioned in Flag 32 of our compendium, it says that freedom of speech and expression guaranteed under Article 19, Clause 1, Subclause A, can only be limited if there is reasonable restrictions given under Article 19, Clause 2. And, however, the criticism of the government and its policies of actions cannot be constituted as a fair ground to restrict the freedom of speech and expression, your lordships.
Where is your right violated, madam, please? Where is your rights violated under 43D5?
Your lordships, the right is classified as violated for the class of people whose names are not mentioned, and but mere sanction, mere belief of the government is necessary to prosecute them, your lordships. That is how our rights are violated under this provision, your lordships. And your lordships, to note, section 2 clause O is very similar to the archaic law sedition, which is mentioned in section 124A of our Indian Penal Code, your lordships. And this sedition law has been put a hold on in the recent 2022 case, which is S.G. Vambadkare versus Union of India, and they have, which is available in flag number 36 of our compendium, your lordships. And now, when the government has, when the courts have realized the abuse of sedition and its similar provisions in section 2 clause O, which is available in our excerpts, your lordships, in the compendium. it shows the blatant abuse which can be done under this section, your lordships. But sedition over here covers hate speech. But what TAPA does is, it goes a step beyond by curbing all forms of speech, your lordships, which can just mean mere criticism of the government, which is available to the citizens of the country, your lordships. And your lordships, it says that in Shreya Singhal case, your lordship, it says that remote disturbance of public order by demonstration would fall outside the scope of Article 19, Clause 2, your lordship. Now, to lay down a landmark case of the misuse of dissenting voices, the council will be laying down the case of Romila Thapar versus Union of India, where 3 accused were charged under the Arms Act, IPC and TAPA, your lordships. And all the accused, the Arun Ferrara was acquitted of all 11 cases charged against him. Varavara Rao was acquitted of all 20 cases charged against him. Vernon Gonzalez was acquitted of 17 out of 20 cases charged against him, your lordships. This itself shows the blatant violation of this act, your lordships. And in this way, Article 19(1) Clause A is violating the fundamental rights guaranteed under this constitution and the right to dissent, your lordships, which is a hallmark of democracy. If the lordships are convinced with the council's arguments, council...
Insofar as, madam, if you look at say, section 7 to 37A, formation of the review committee,
Yes, your
it
lordships.
is the subjective satisfaction of the authority.
Yes, your lordships.
If it is a subjective satisfaction of the authority, then it will be placed before a review committee.
Your lordships, to
If
answer
such
your...
been the case, how can you argue that it's a violation of 19(1)A?
Your lordships, to answer your question, your lordships, that TAPA has established a low conviction rate, which is just merely 2.8%. Now, the low conviction rate results to malicious prosecution. Now, to lay down a case to answer your question, your lordships, that is Adambari, Sulembai, Ajmeri and others versus state of Gujarat. Over here, it says that the person who are accused of terrorism were in prison for 10 years before being acquitted, your lordships. And the 6 people under this act were wrongly accused, and they had to spend 10 years in prison, which shows a long trial process just because they dissented the government, your lordships. And that is how it is violating our rights, your lordships. This is what the council wants to lay down, your lordships.
But the security of the state is also equally important.
Yes, your lordships. The
Then, in the event if you are allowed to do like this, in the event if they have not taken any decision to arrest you, then the predicament of the same will be different.
Your lordships, the government has guaranteed safeguards for certain class, but what about the people mentioned under section 45 of the act, your lordships? They have only because if the government believes them to be involved in terrorism, they will have to go through a lengthy trial process, and they have no provision for bail because of the stringent provisions of bail, your lordships. Over here, the bail provisions extend up to 180 days
No,
also,
if you
your
look at the
lordships.
problem, it is a conjoint of both preventive and punitive detention.
Yes, your lordships.
That's why.
But your lordships, just on mere belief, a government cannot prosecute an innocent person and cannot keep him in prison for nearly 10 years. And there have been many precedents this court has laid down where people have been wrongly abused by this act, your lordships. And that is why Article 19(1) Clause A has been infringed, and infringing the right to dissent, your lordships, especially even by being so similar to sedition law, your lordship.
Yes.
Your lordships, council seeks permission to move on to the next issue.
Madam, your grievances against the discrimination and then disparity and without any basis of arrest and being in custody. Now, there is a remedy available for bail.
Your lordships, the act has provided safeguards only for a certain class. What about the other class of people who haven't been given safeguards? Why? Because the other people have a speedy trial justice, which is guaranteed in our very constitutional rights, your lordship. The other class of citizens do not have this, your lordships, and that is the main concern. And these people are subjected to a long trial process, but the others aren't, your lordships, and that is the main
What
concern.
is the point of law with regard to grant of bail during the process of trial?
Your lordships, in a cognizable offence, your lordships, as mentioned in TAPA, your lordships, it has mentioned an extended period of 180 days, your lordships, and not 90 days as mentioned in 167 of the CRPC, your lordships. And not just that, your lordships, on mere belief of the government, your lordships, a person will be prosecuted. And after that, it also talks about case diaries or anything else which can prohibit a person from being released from bail. Their default bail provisions are being rejected, your lordships. And what if you are an innocent citizen What is the liability of the government if you are acquitted after 10 years, your lordships? There is no liability on behalf of the government, your lordships, and this is a concern of the citizens of the country, your lordships. And that is why the fundamental rights have been violated under this Act, your lordships, and the council is merely asking for safeguards to be provided under this Act, your lordships. Your lordships, moving on to the second contention, that is whether the power to classify someone as a terrorist without trial or judicial making process violates the established norms of criminal justice. It is humbly submitted before the Honorable Court that the power to classify someone as a terrorist without trial or judicial making process is violative of the established norms of criminal justice, your lordships. To substantiate the same, the council will be doing it under three sub-contentions. The first being the discretion to name individuals as terrorists. Is it draconian? Now, the presumption of innocence is a cardinal rule of our criminal justice system, as laid in the case of Ramanand versus State of Uttar Pradesh, your lordships. And also, Article 4 of the International Covenant of Civil and Political Rights states that a government may deviate from protecting a person's civil and political rights only in case of extreme emergencies. Now, the government has failed in showing the extreme emergency in departing from its main mission by classifying individuals only into two types, your lordships. And Section 35, Clause 2 states that if a name of an individual can be mentioned in the schedule based on mere belief. Now, the grounds of mere belief are also vague, your lordships, and there is no prescribed period for denotification. Now, if you're charged under unlawful activity and you're an organization, you have a denotification period of 5 years mentioned under Section 6, your lordships. But for an individual charge of the same, you have no remedy. There is no denotification period for you, your lordships. And if you're charged of unlawful activity, as the council is mentioning, your lordships. And your lordships, in Section 36, it allows the appeal for appeal of the label, your lordships, and its implementation is also difficult when the grounds of arrest only are not known, your lordships. And moving on to Section 37, the review committee under Section 35 and 36. This review committee has to adhere to judicial principles, but no standards have been set for authority granting sanction, thus reducing to a mere administrative exercise, your lordships. And under Section 52, your lordships, it has been stated that the government can make rules, but the government has made no rules on how a sanctioning authority is to independently review, your lordships. How can it be absolutely up on the discretion of the government, your lordships? There should be transparency in law, especially a criminal law like this, your lordships. And your lordships, the review mechanism is unavailable for individuals who are classified under unlawful activity, your lordships. And the organizations have a recourse to a tribunal under Section 3.
But that review, if you look at the parameter of Article 22, Class 3, 4 of
Yes, your
Indian
lordships.
Constitution, where they review whether the arrest is valid or not, whether the procedure contemplated under the Act is followed or not. Except that, nothing much insofar as nothing but an advisory board, nothing but an opinion that they will give. Anyway, there is a check by the learned judges insofar as exercising 37A of the Act.
Your lordships, the council wants to say that this advisory board is set up under the Indian Constitution, your lordships. But over here, an independent review is our concern, which is mentioned in this section, your lordships, which grants and it's not about the independent review, which is Section 37. We are dealing with Section 45, your lordships, which has where the independent review is there. And this independent review, your lordships, there has now the review committee has to conform to judicial principles. But what about this independent review? They have not mentioned it all. It is just nothing but a mere administrative exercise, your lordships. And no rules on how they have to function is also being mentioned, your lordships. Moving on, your lordships, to the recent amendment mentioned in our Moot proposition, your lordships, that is Section 43G, which makes confessions made to a police can be taken into consideration. Now, this is the repealed provisions of Section 15 of TADA and Section 32 of POTA have been reinstated, your lordships. And in the case of Dagdu versus State of Maharashtra, it explains the nature of police investigation. The police try to get the confession hook or by crook, your lordships. And instead of trying to start from a confession, they they should try to arrive at it, which is not done. And there's a lot of precedent set for it, your lordships. And Section 25 and 26 of the Indian Evidence Act of 1872 provides such confession is inadmissible unless it is made in front of a magistrate. There has been no safeguards which is provided, your lordships, under the present TAPA which has been mentioned in our Moot proposition. There has been no safeguards which has been provided for these people. And also in the case of Kartar Singh versus State of Punjab, mentioned in flag 12, it says that confession is admission of guilt, a law which entitles a police officer to record confession and make it admissible is thus violative of Article 20 Clause 3 and Article 21, your lordships. And your lordships, moving on to the next sub-contention, which is the parity between TADA, POTA and TAPA, your lordships. The main objective of all these
What
three...
is your argument with what the government should do and what law should be brought or amendment should be made?
Your lordship,
With regard to confessions, which is applicable under the Evidence Act and the other provisions.
Your lordship, under Evidence Act, the confession should be made in front of a magistrate, not a police officer, your lordships. And your lordships, reasonable safeguards should be provided. What if there's a custodial violence against a person to get evidence, your lordships? And there have also been cases, your lordships, that is NCT versus Navjot Singh Sandhu, where incriminatory evidence by the police, your lordship, it empowers police to take evidence which is self-incriminatory, your lordships, which has been mentioned in this case, your lordships. And that is why the council requires safeguards, your lordships, which protects a person from such brutal, malicious intent of the police officers, your lordships, just to get a confession, to get their work done, your lordships. And your lordships, the council would want to bring in the similarity between TADA, POTA and TAPA. Now, all these three are used to combat terrorism, your lordships. And it is to be noted that anti-terrorism laws have a legacy of giving the government unlimited power to curtail fundamental rights, which has thus led to the repeal of TADA and POTA, your lordships. Now, to bring the attention of the court to the conviction rate under all these acts, TADA had a 1.11% conviction rate, POTA had 1.2% conviction rate. Following the same footsteps, TAPA has 2.8% conviction rates. And this has been given in the NCRB reports of 2015 to 2020, your lordships.
Whether the conviction rate is the basis for nullifying the laws?
No, your lordships, conviction is not the basis, your lordships, but it just shows how inefficient the law is or the malicious intent, because there is no reasonable safeguards which have been provided, because it shows how many people are being acquitted of malicious prosecution of the malicious prosecution, your lordships. That is what is happening under this. Now, your lordships, in the case of Indra Das versus State of Assam and Arup Bhuyan versus State, it has mentioned that Section 10 of TAPA and Section 5 of TADA makes mere membership of a banned organization criminal. Now, the court has held it to be violative of Article 19 and 21. They have said that mere membership is not criminal unless he resorts to violence, your lordships. The council is wondering why just mere membership is considered to be an offence, your lordships. And your lordships, to note, the counterparts POTA and TADA had a sunset clause which allowed periodic review, your lordships, of 2 and 3 years. But TAPA is devoid of the same, your lordships. And your lordships, Section 43D5 of TAPA and Section 20 of TADA are very similar by giving an extensive detention period of 180 days, your lordships. What about people who have been convicted because of mere belief of the government? Even they are subjected to all this, your lordships. And your lordships, moving on to the next concept, which is bail, your lordships.
There's a presumption initially, but it's a rebuttable presumption. You go and disprove.
Your lordships, but over here, if you are being convicted of an offence, your lordships, under TAPA, you have been detained for a long period of time, your lordships, and it is all, and the reports are all based on it's in favor of the government, your lordships. And to lay down this, I will be mentioning the case of National Investigative Agencies versus Zahur Ahmed Shah Batali, your lordships. It has been said that the bench cannot venture into the merit and demerits of the case. This means the court has to accept NIA's version of events, making bail hard, because assessing any exculpatory evidence provided by the accused would be charging on its merits. Means if the courts cannot even check the merits of the case, over here you're going to be sitting in jail until the government thinks it's fit for you to come out, your lordships. Council seeks 1 minute time and extension of justice.
In Zahur's case, what does the law lay down?
Can you please repeat the
In
question?
Zahur's case, Watali's case, what is the law laid down with regard to bail?
Your Lordships, the act which is dealing with it itself is TAPA, Your Lordships. And 43D5, they have mentioned about its arbitrary use and how its rigors will melt down the provisions of bail, Your Lordships. And this has been laid down in this case, Your Lordships. Yes. And Your Lordships, in Shaheen welfare case also, it has been mentioned that stringent bail conditions and special criminal legislation would be justified only if swift trial took place. Otherwise, it would be violative of Article 21. And Your Lordships, there have been cases where certain courts have taken upon the discretion to release the person because of the violative provisions of Section 43D5, Your Lordships. Even in the case of Union of India versus K.A. Najib, it has been laid down that 43D5 merely provides another possible ground for a competent court to refuse bail, Your Lordships. And that is why, Your Lordships, they have not followed the principles of criminal justice, and the prosecution rests their case, Your Lordships.
I mean, after following Zahur Watali Najib's case and thereafter the latest judgment of this court, it is made clear that bail is the rule and jail is an exception.
No, Your Lordships. In a cognizable offence, bail is not the rule, Your Lordships. That is the problem over here, Your Lordships. When the bail becomes a privilege in a cognizable offence, what do people who have been convicted of mere belief do, Your Lordships? That is why, Your Lordships. If the bench is satisfied with the arguments of the counsel requests co-counsel to deal with the rest of the issues.
Yes.
The counsel seeks permission to approach.
Yes.
The council shall be dealing with issue number 3. Issue number 3 being whether the amendments made to the Terrorist Activities Prevention Act 1967 is arbitrary and violative of the fundamental rights of the Constitution. It is most humbly and respectfully submitted before the Supreme Court of India that the amendments made to the TAPA 1967 is arbitrary and violative of the fundamental rights of the Constitution. Now, the council would like to establish the same with dealing with several sections of the amendments which are arbitrary and violative of the fundamental rights of the Constitution. First, Section 37 and Section 37A. For the convenience of the bench, the council would like to read the provisions of Section 37 and 37A. 37 talks about review committees. The central government shall constitute one or more review committees for the purposes of Section 36. Every such committee shall consist of a chairperson and such other members not exceeding 3 and possessing such qualifications as may be prescribed. A chairperson of the committee shall be a person who has been a judge of the High Court who shall be appointed by the central government, and in the case of appointment of a sitting judge, the concurrence of the Chief Justice of the concerned High Court shall be obtained. And Section 37A, Your Lordships, tells about the review committee constituted by the central government under Section 37 Clause 1 of the Terrorist Activities Prevention Act. This shall review the cases registered under the TAPA 1967 as to whether there exists a prima facie case or not, Your Lordships. And the review committees, if it is of the opinion that there is no prima facie case, then in the cases which cognise has been taken by the court, the cases shall be deemed to have withdrawn. And in the cases which investigations are pending, the investigation shall be closed forthwith with the effect from the date of issuance of the direction of such review committees. Now, Your Lordship, the petitioner would like to contend the fact that this section is arbitrary and violative. The problem with this section is there is only limited scope for the judiciary to interfere in the arrests of individuals, Your Lordships, because the total autonomy is with the central government and review committee, which is also appointed by the central government, Your Lordships.
This review committee opinion is distinct from challenging the order.
Your Lordships, the council is like to council would like
It
to
is
tell.
only the review committee means that the role of the committee is to see whether the procedure adopted by the authority is just and proper.
Indeed, Your Lordships.
In the event, then the review committee will give a report.
Indeed, Your Lordships.
Thereafter, the government will take some decision in the matter.
Indeed, Your
However, it is open for the petitioner or the accused to challenge the order,
Your
confirmation order.
Your Lordships, the council is not challenging the fact that there is a provision to approach the court, Your Lordships. But prima facie, only after the sanction is given by the central government, Your Lordships, that the petitioners are allowed to go. The interference of judiciary in the arrests of the individuals, Your Lordships, is questionable. Further, Your Lordships, the committee is not burdened to reason their verdicts, Your Lordships. This adds further possibilities to manipulate the verdicts. Your Lordships, further, this bypasses the fundamental rights of the Constitution and due process by incarcerating the individuals for up to 180 days. Your Lordships, 37A was merely enacted because the government of India realized that there is an increase in unwarranted trials, Your Lordships. The NCRB report from 2015 to 2020 clearly shows that there is an abysmal of 2.8% low conviction rate, Your Lordships, and there is a huge gap between the people who were arrested and the people who were convicted, Your Lordships. This clearly shows that there is a malicious prosecution and unwarranted arrest. So even if you compare the IPC and the TAPA, the low conviction rate of a TAPA.
Right. Madam, one question for you. How do you come to a decision that it is an unlawful it is only after the post-trial and conviction? Only then you realize that after he's acquitted.
Your Lordship, the council is trying to tell that 37A, which is a review committee, prima facie, if it decides whether there exists a case or not, this is only done because the government realized that there is a low conviction rate. Now, this low conviction rate is resulted because if you see the statistics, Your Lordships, the people who are arrested and the people who are convicted, there is a huge difference between them. This clearly shows there has been an unwarranted conviction. And the Act also does not provide the liability of the government authorities for the people who are unwarrantedly convicted or maliciously prosecuted, Your Lordships. So what is of those people who are unwarrantedly convicted in such huge numbers, Your Lordships, just basis on the prima facie satisfaction of the competent authority, Your Lordships. Moving on, Your Lordships, with Section 18. Section 18 of TAPA provides that whoever conspires or attempt to commit or advocates, abets, advises or incites, directs or knowingly facilitates the commission of the Terrorist Act or any perpetratory commission of the Terrorist Act shall be punishable with the imprisonment of not less than 5 years, which may extend to imprisonment of life and also be liable to fine. Your Lordship, Section 18 covers terrains of action which deals with incitement and conspiracy. Now, Your Lordships, the Indian Penal Code, Section 120A(b), Section 121 also deals with conspiracy, Your Lordships. In the case Ajmal Kasab versus State of Maharashtra, it was clearly held that it is wrong if the definition comes under Section 15 would be fall out of IPC 121 because court was of the opinion that the
Review committee will come into exist only in preventive detention, not in punitive.
Your Lordship, if you would...
Those are the judgments that you are referring to in so far IPC, they are of punitive, not preventive.
Your Lordships, this judgment was also because one of the contentions was the IPC provisions, it acts as an overriding provision because there exists already a provision in the IPC. Now, the court was of the opinion that it is wrong that if the definition comes under Section 15, that it would fall out of IPC 121. So, it says that IPC 121, which deals with waging war, section which deals with the waging war, and this Terrorist Act, waging war already covers the part which comes under the Terrorist Act, Your Lordship. So this acts as an overriding principle which gives more ambiguity. Now, Your Lordships...
Madam, whether the IPC covers the definition of terrorist?
Your Lordships, the court was of the opinion that the terrorist activities also will come under the section which deals with waging war.
No, whether the act of terrorism or terrorist is defined under the IPC.
Your Lordships, indeed not, Your Lordships. Your Lordships, even in the preceding terror laws, which is TADA and POTA, this were also widely abused to implicate and thousands of people just in the name of conspiracy, Your Lordships. The police officials would arrest anybody and everybody just because they believed that they did a crime. This is just an agreement to commit a crime, Your Lordships. The object of the agreement has not been occurred yet, before which the police officials used to arrest, Your Lordships. Further, Your Lordships, this promoted the Supreme Court in the case of Shaheen Welfare Association versus Union of India that they classified only hardcore criminals should be kept in jail as under trials and others should be released in bail, Your Lordships. Hence, the conspiracy is convicting a person just on the basis of conspiracy, Your Lordships, is ambiguous in nature, and also the section which deals with conspiracy in TAPA, Your Lordships, acts as an overriding principle. Moving on to Section 35, Clause 2. Section 35 clause 2, your lordships, after amendment, the state included individuals along with the terrorist organization to be termed or tagged as the terrorists. Now, your lordships, the petitioner is not questioning the validity of how they put individuals to be termed as a terrorist, because the petitioner also acknowledges the security and integrity of the country. The petitioner is merely challenging the fact that the state does not adhere to the procedure established by law. Here, your lordships, when the individual is tagged as a terrorist, even before the commencement of the trial or any application of the judicial mind, your lordships, thus violating the procedure established by law. Further, your lordships, it also violates an intrinsic aspect of Article 21, which is right to reputation, your lordships. In the case Subramanian Swamy versus Union of India, right to reputation was recognized as an integral part of the right to liberty, your lordships, under right to life and liberty, your lordships, under Article 21. So this is clearly violated in this section by publishing their
Madam,
names.
Don't you agree with the fact that the integrity and honor and security of the nation is the prime most?
The council completely agrees to it.
You
your
agree?
lordship. Your lordship.
Then when people are waging war and trying to breach the security integrity of the nation, they should not be even tried?
Your lordships, the council is not contending the fact that they should not be tried. The council is contending the fact that while making a trial, there is no procedure established by law, your lordships. The state is not following the procedure established
No,
by
there is
law.
bail provisions available. You can approach bail, pre-trial bail.
Your lordships, again, your lordships, to reach to the trial stage itself, there is so much of scrutiny given by the government, your lordships, again, which are controlled by the central government. So nobody knows what competent authority is dealing with it. It's all enclosed in one authority itself, your lordships.
Challenge that authority, go before the court, obtain bail, put forth all your case and say that it's a false fabricated case against you.
Your lordships, again, that the petitioner is challenging the fact that the central government has autonomous power, your lordships. The council is praying to the court that this section which allows the central government to have autonomous power should be held as unconstitutional, your lordships, because there is an abuse, constant abuse by the police officials, your lordships. This is clearly proven in the malicious prosecution cases. Your lordships, the Subramanian Swamy versus Union of India recognizes right to reputation, which has clearly been violated here. The International Covenant on Civil and Political Rights also recognizes the right to reputation as an integral part and to hold opinions without any interference. Your lordships, further, Article 14, that is right to equality, is also been violated in this section, your lordships. The one aspect of which is on what basis the classification of the individuals, as my co-counsel established, that there are two types of classifications of individuals. One are published and one are not in Schedule 4. On what basis this classification made? Again, the center remains silent about it, your lordships. Another place where Article 14 is violated is no denotification for individuals is given with respect to unlawful associations, your lordships, only for terrorist organization, your lordships. So this, again, there is no reasonable classification to it. So this clearly violates fundamental rights of the Constitution, your lordships. Hence, Article 35 Clause 2 should be held as unconstitutional. Even the case Indira Das versus State of Assam tells that literal interpretation of these provisions would be violative of the Articles 19 and 21 of the Constitution, your lordships. This was the line in. This was also the line in Arup Bhuyan's case.
What are the yardsticks to be looked into when the legality of a particular provision is challenged?
Your lordships, the provision should not violate the fundamental rights of the Constitution. The provision should not be ambiguous in nature, your lordships, and it should follow the due process of law.
And apart from?
Your lordships, these are the basic principles that has to be followed.
Yes. But Article 245 has to be looked into.
Indeed, your lordships, but the basic concern of the petitioner here, it should not be arbitrary in nature, and it should follow the fundamental rights of the Constitution.
Yes.
Moving on to Section 45 of TAPA. Now, Section 45 of TAPA mandates that no court shall take cognizance if there exists if there does not exist a valid sanction from the competent authority. Now, the Council agrees that various courts have established that If there exists no valid sanction, the court cannot take cognizance of it. But, Your Lordships, in the case State of Maharashtra versus Mahesh Kariman Tirki, which is in flag number 45, the Supreme Court stayed the order of High Court of Bombay, where the accused G.N. Sai Baba was who had alleged moist links, who was acquitted on the basis of 90% disability, Your Lordships, and also the basis of acquittal was that there was insufficient sanction. Now, court was of the opinion that High Court did not go into the merits of the case, and also it only considered the sanction, which is a procedural aspect of the case, Your Lordships. Again, the literal interpretation of this section, Your Lordships, is violative of the constitutionalism, Your Lordships. Again, it limits the powers of the court to take cognizance just on the basis of a procedural aspect, Your Lordships. Further,
Madam, when there is a procedural act violation or a deviation, there are certain things which are curable and with certain things which are not curable. It's a curable defect, it can be cured.
Your Lordships, again, but the trial has gone, Your Lordships. The High Court merely relied on the fact that there was procedural law which is insufficient, Your Lordships, which in this case was sanctioned. So the Supreme Court was of the opinion that this does not go into the merits of the case, because only considering the procedural aspect, Your Lordships, is not according to the Constitution. Further, Your Lordships, in this CRPC Article 4, Section 465 deals with curable defects, Your Lordships. It provides that any grievance against an irregular sanction should be raised at the earliest opportunity. Now, Your Lordships, there is an overriding clause in TAPA, which is Section 48, that provides a similar provision to ensure that the overriding clause, to ensure that any enactment is not inconsistent with the TAPA provisions. Again, this overrides the CRPC, Your Lordships, further increasing the level of ambiguousness. Moving on, Your Lordships, for Section 20 and Section 38. Section 20 and 38, Your Lordships, both of them talks about being a member of terrorist organization. For the court's convenience, I'd like to read the provisions. Section...
You can proceed further.
Indeed, Your
You
Lordships.
do not
Indeed,
need
Your
to read
Lordships.
it. You can proceed with the argument.
Indeed, Your Lordships. So Section 20 and Section 38 talks about membership of terrorist organization. So they are so similar in nature that there is a scope of confusion and arbitrariness. Even in the recent case, which is Twaha Fasal versus Union of India, the same was challenged before the court that 20, 38, 39 are very similar in nature, Your Lordships, because all of them gives the punishment for being a member of the terrorist organization, and the state has failed to establish what makes one different from the other, Your Lordships. Hence, for a person to be held in an offense, Your Lordships, this acts as a very ambiguous clause, and this opens up the scope for the state authorities to abuse their powers, Your Lordships. Further, Your Lordships, Section 43E. Section 43E talks about presumption of guilt, Your Lordships. Here, the accused is presumed to be guilty unless the contrary is proven. Now, Your Lordships, presumption of innocence is kind of a restatement rule that is applied in criminal matters. 43E states that unless contrary is proved, they are assumed to be guilty. Your Lordships, in the case State of Maharashtra versus Vasudeva Ramachandra Kaidalwar, the expression of burden of proof has two meanings, legal burden and an evidential burden. Now, in the trial, the accused is considered to be innocent until proven guilty, Your Lordships. And the prosecution carries the burden to prove the guilt, and this burden to prove anything essential against the accused is the legal burden which never shifts, Your Lordships. Hence, the presumption of innocent until proven guilty forms a cardinal rule of criminal jurisprudence, Your Lordships. Further, in the case NCT versus Navjot Singh Sandhu, this is a famously called as Parliament attack case, Your Lordships. The confessions made by the accused were severely abused by the state authorities, Your Lordships. Even the court seriously doubted the competence of these confessions made by the accused in front of the deputy commissioners as well as the police officials, Your Lordships. Even the POTA, which was repealed in 2004, had this unmistakable evidence and self-incriminatory sections, Your Lordships. Now, when TAPA was formed, it also incorporated some of the provisions of POTA, one of which was this self-incriminatory clause as well, Your Lordships. Your Lordships, in the recent case Vijay Mandal Chaudhary versus Union of India, the Prevention of Money Laundering Act 2002 was also challenged based on the same ground that the burden of proof only shifts on the accused, Your Lordships. And the court was of the opinion that this will violate Articles 21 and Article 14 of the Constitution, Your Lordships. Hence, 43E of...
Now you were speaking about the burden of proof, and there should not be a presumption because until proven.
Indeed, Your
There are several other enactments like what you just now said, PMLA.
Indeed,
there
Your
is
Lordships.
POXO, there
Your
is
Lordships.
negotiable instruments, and there is also the other prevention of money laundering.
Indeed, Your Lordships.
So
The-
there is a rebuttable, that is a rebuttable presumption.
Indeed, Your
So you
Lordships.
can rebut it, you have the right to rebut it.
Your Lordships, the Council is not questioning the validity of the other enactments which also follows the similar principle, Your Lordships. It acknowledges the fact that other criminal laws such as IPC, PMLA also follows this, Your Lordships. But in existing of this provision in a terror law, like established in NCT versus Navjot Singh Sandhu, the court disregarded the involuntary confessions, Your Lordships, because there was an abuse from the police officials, Your Lordships. So, existing of this provision in terror laws goes against the right of the accused, Your Lordships. Hence, Your Lordships, 43E of the TAPA does not provide any, follow the Constitution and hence violates the provisions of the Constitution, Your Lordships. Hence, 43E should also be struck down. Your Lordships, if you're satisfied with my arguments, I'd like to move on with the prayer. Wherefore, in the light of the contentions presented, arguments advanced, authorities cited, the Council for Petitioners most humbly and respectfully submits before the Honorable Supreme Court of India that it may adjudge and declare that the amendments made to the Terrorist Activities Prevention Act 1967 violates the freedom of speech and expression guaranteed under Article 19, Clause 1, Clause A by restricting the right to dissent. The power to classify a person as a terrorist violates the established norms of the criminal jurisprudence. The amendments made to the Terrorist Activities Prevention Act 1967 violates the constitutional provisions and ultra-vires to the Constitution of India and should be declared as unconstitutional. The court may also pass any order as it may deem fit in terms of equity, justice and good conscience, and for this act of kindness, Your Lordships, the Council shall forever humbly pray. It was a pleasure arguing before your bench, Your Lordships.
May it please this Honorable Court, this is Counsel appearing on behalf of the respondents in the case of Freedom Forever and Others versus Union of India. The petitioners had approached this Honorable Court under Article 32 of Indian Constitution, Your Lordships. The Council will be dealing with issues 1 and 2 and the first part of issue 3. And my co-counsel speaker 2 will be dealing with the second part of issue 3 and issues 4 and 5. Would Your Lordships appreciate a very brief perusal of the facts, Your Lordship?
Facts are already narrated, you can go to your argument.
Much obliged, Your Lordship. Your Lordship, the issues that the Council will be dealing with are as follows. Whether the Parliament has legislative competence to pass the Terrorist Activities Prevention Act, whether the TAPA violates Article 14 of the Constitution, and if it violates Article 21 of the Constitution, Your Lordship. With this, the Council is moving on to the arguments of the first issue, where I'll be establishing that the Parliament has the legislative competence to pass the TAPA. Your Lordship, the terrorist attacks are in the nature of shackling the entire nation's tranquility, Your Lordship, and affecting the lives of huge number of people is in itself a mass fundamental violation, Your Lordship. Your Lordship, to describe terrorism as gruesome is the very least of its description. And Your Lordship, the existing ordinary criminal jurisprudence is grossly inadequate to deal with such activities, Your Lordship. Your Lordship, it is admitted that the impugned act falls within the ambit of entry 1, list 1, namely Defense of India, under the 7th schedule of the Constitution, Your Lordship. Hence, it is within the legislative competence of the Parliament and also in view of Article 248, read with entry 97 of list 1, all the residuary powers of the powers are also vested with the Parliament, Your Lordship, and it has the legislative competence henceforth. Your Lordship, the Lordships might wonder how why the council is establishing the legislative competence, because even though the petitioners had not contended, it is a proactive step by the respondent in order to set up the res judicata in this matter. For the future cases, this will be a binding decision, Your Lordship. And also, this will provide as the basis for the next issues that I'll be handling. Your Lordship, in the case of Ram Manohar Lohia versus State of Bihar, Justice Hidayatullah had brought out the distinction between law and order and security of the state in the following observation that one has to imagine 3 concentric circles. Law and order represents the largest circle, within which the next circle representing public order, and the smallest circle represents security of the state, Your Lordship. Your Lordship, security of the state is very particular in nature, and only the Parliament is capable of construing it effectively and enacting an act for the same, Your Lordship. Your Lordship, moreover, public order in the state empowers the state to enact legislation only relating as far as it affects the particular state, Your Lordship. However wide a meaning is ascertained to public order, the present day problem of terrorism cannot be read into the same, Your Lordship, and the same is held in the PUCL versus Union of India, Lordship. If Your Lordships are satisfied that the Parliament has the legislative competence to enact TAPA, can the Council move on to the next issue, Your Lordship?
Yes.
Your Lordship, the next issue deals with whether TAPA violates Article 14 of the Constitution. Your Lordship has humbly submitted that the Act in no way violates Article 14 of the Constitution. Under TAPA, any individual or organization can be named a terrorist or a terrorist organization, respectively, under Section 35 of the Act, on the belief that they are involved in terrorist activities, Your Lordship. Here, those who have been found suspect in committing an offence of such gravity, Your Lordship, are classified separately under this legislation, which is a departure from the normal criminal jurisprudence, Your Lordship. Your Lordship, any classification such as this should pass the twofold test of intelligible differentia and rational nexus, Your Lordship. Moving on to the first fold of my issue, I'd be establishing that TAPA passes the test of intelligible differentia. Your Lordship, Section 15 of the TAPA.
Do you mean to say that Article 14 comprises of only 2 of these components? Is not manifest arbitrariness a part of the Article 14?
Your Lordship, that I'd be dealing under intelligible differentia as well. I've included it in intelligible differentia, Your Lordship. Your Lordship, Section 15 of TAPA clearly defines what constitutes a terrorist act, Your Lordship. Your Lordship, in the very first line of Section 15, it establishes the mens rea to threaten the integrity, security, or sovereignty of India, Your Lordship. Moreover, the petitioners contend that the phrase by any other means of whatever nature under Section 15 is vague and provides arbitrary powers to the central government, Your Lordship. Your Lordship, this is humbly contended by the respondents, because the principle of aegisdem generis is required to be applied for this provision, for this phrase, Your Lordship. And the Council concurs even with the decision in Asif Iqbal Tanha with the state of Delhi NCT, where it was held that the provisions of Section 15 of UAPA are required to be narrowly interpreted, Your Lordship. Your Lordship, this is a direction to the judiciary. And nothing per se is wrong with the legislation, Your Lordship, and they're seeking to strike down the legislation, saying it's unconstitutional. Your Lordship, this is where the Council is submitting that nothing per se is wrong with the legislation, and misusing the legislation cannot let the legislation drain, Your Lordship. Legislation cannot be unconstitutional, Your Lordship, here. Your Lordship, it is further submitted that the phrase by any other means of whatever nature is absolutely necessary as well to bring within the ambit of the provision the emerging means of terrorism, Your Lordship. Today we have cyber terrorism, which doesn't fall under any of the other terms specified in Section 15, Your Lordship. Your Lordship, thus it is established by the Council that there is a systematic way to group these persons and organizations, and there is no arbitrariness per se in, and it does not violate Article 14, Your Lordship. Under Article 14, it is also stated that unequals cannot be treated equally, and that in itself would lead to inequality, Your Lordship. Your Lordship, these accused are categorized in a separate category, and this is a very grotesque offense in nature, Your Lordship. Terrorism cannot be equated with normal penal offenses, and thus they should be treated differently, and extraordinary criminal procedure should be applied for this, Your Lordship. Your Lordship, in the case of Bimal Kaur versus Union of India, the High Court of Punjab and Haryana examined a very similar challenge as to the wires of Section 20, Clause 7 or 20, Subsection 7 of Terrorist and Disruptive Activities Prevention Act, which was the prior act that was there before this TAPA, Your Lordship. And Your Lordship, the court held the provision was intra-virus the Constitution as persons charged with the commission of terrorist act fall in the category which is distinct from the class of people charged with offences under the Indian Penal Code, Your Lordship. Your Lordship, this is submitted as a authority, and that is, it is humbly submitted that TAPA passes the test of intelligible differentia as there exists a proper and definitive measure by which they are classified, and that it is not arbitrary as well, Your Lordship. Your Lordship, moving on to the second fold of my argument, it is humbly submitted that TAPA passes the... Yes, Your Lordship.
So now freedom of speech is available
Your Lordship.
to a citizen? So if you speak anything about the government, then you frame him under this provision?
Yes, Your Lordship, the
How do you
petition...
say it is not arbitrary?
Much obliged, Your Lordship. Your Lordship, the petitioners have argued extensively on the freedom of speech and expression and dissent, Your Lordship. But however, Your Lordship, it is submitted that it is beyond the facts of the case, and it is nowhere found in the proposition as to the freedom of speech and expression and dissent, Your Lordship, and the council would humbly like to avoid that submission. Your Lordship, in the... yes, Your Lordship. Your Lordship, according to the principle of national nexus, any classification that is based on intelligible differentia should have a logical relationship to the object that is sought for by the legislation, Your Lordship. Your Lordship, Section 43E of TAPA gives the presumption as to the offences under Section 15. Your Lordship, this is also extensively contended by the petitioners, Your Lordship. Your Lordship, the petitioners contended that Section 43 of TAPA presumes any innocent person guilty of offences under Section 15, according to the whims and fancies of the central government, Your Lordship. Your Lordship, I request the court's attention to Clause A and B of the same section, where it provides a foolproof prima facie evidence only based on which they will be presumed guilty under Section 15, Your Lordship. Your Lordship, I read verbatim from the legislation. Clause A reads that the arms or explosives or any other substances specified in the said section were recovered from the possession of the accused, and there is a reason to believe that such arms or explosives or other substances of similar nature were used in commission of such offence, Your Lordship. Your Lordship, similarly in Section B, so Clause B, it is stated that by evidence of the expert, the fingerprints of the accused or any other definitive evidence suggesting the involvement of the accused in the offence were found at the site or Your Lordship, it goes on. Your Lordship, it is thus definitively defined in Section 43E as to how they can be presumed guilty of Section 15, Your Lordship. And that is where the...
Yes, one of the argument advanced by the petitioner
Yes,
was it is a draconian law.
Yes, Your Lordship.
And moreover, unless the government gives sanction and there is no right, fundamental right will be violates. See, in this connection, what do you say actually? That light of the matter that you have to argue. The first contention raised by them was, it's a draconian law.
Yes, Your Lordship.
Without any procedure, you will arrest and you can take law into action.
Yes,
and
Your
it is vested with the executive.
Yes, Your Lordship.
So that's what the argument advanced by the other side.
Yes.
How to deal with all these things actually?
Your Lordship,
What is your answer for this?
Yes, Your Lordship. Your Lordship, those questions would be extensively answered by my co-counsel in his subsequent issues, Your Lordship. Your Lordship, in making the classification, various factors have to be taken into consideration and examined as to whether such distinction subserves the object of the legislation, Your Lordship. As pointed out in the earlier sub-issue, persons charged with offences specified in TAPA or distinct class of persons as the council has already established. Your Lordship, the case of State of Bombay versus FN Balsara, Justice Fazan Ali, approving the scope of Article 14 discussed in Chitranjit Chal vs. Union of India, laid down a proposition where he says, the presumption is always in favor of the constitutionality of the enactment, since it must be assumed that legislature understands and correctly appreciates the needs of its own people, Your Lordship. And it goes on, and it is discussed in page 70 of the memorandum for the reference, Your Lordship. Your Lordship, this lays down the doctrine of presumption of constitutionality of the legislation, and it is it also subserves the object of the legislation, Your Lordship, and thus it is humbly submitted by the Council that the Terrorist Activities Prevention Act passes both the test of intelligible differentiation and rational nexus, and this is not violative of Article 14, Your Lordship.
What about arbitrariness? Manifest arbitrariness.
Your Lordship, that was also dealt in, under intelligible differentia by the Council, Your Lordship.
No. That was Justice Tendulkar case. Earlier, Tour's test, nexus, that is called as nexus test. Now the much water has flown.
Okay.
Now the manifest arbitrariness is also one of the criteria to be satisfied while testing legality of the legislation under Article 14.
Much obliged, Your Lordship. Your Lordship,
What do you say about that?
Yes, Your Lordship. Your Lordship, the petitioners contained section 35 of the legislation, Your Lordship, where the central government, as they say, is allegedly arbitrarily including individuals and organizations under the ambit of the Act. Your Lordship, this is contended by the Council because in subsection 3 of the same section, it lays down as to how they can be added to the schedule, Your Lordship. Your Lordship, thus it is devoid of any arbitrary, there is no scope for arbitrariness at all, Your Lordship. And there is clear measure and a clear yardstick as to how they will be brought into the provision, Your Lordship, and will be penalized, Your Lordship. If the Lordships are satisfied, can the Council move on to the next issue? Your Lordship, the next issue is whether TAPA violates Article 21 of the Indian Constitution, Your Lordship. Your Lordship, the Council humbly submits before this Honorable Court that the instant matter TAPA is in no way violation of Article 21 of the Constitution and is in line with the procedure established by law. And Your Lordship, in the case of ADM Jabalpur versus Shivkant Shukla, Your Lordship, in this case, it was held by the bench that national security prevails over individual liberty, Your Lordship. Your Lordship, that the detention was valid as it is according to the procedure established by law.
That judgment is overruled now.
It's purely of persuasive value, Your Lordship.
If it is overruled, how does it become persuasive? If it is overruled, it goes, it's virtually non-est. You can't cite it.
Profusely apologize for the same, Your Lordship. In the instant case, TAPA as well as the detention is carried out according to the procedure established by Your Lordship. The Parliament is empowered to create a legislation for the protection of national security, and to that extent, restrictions on Article 21 can be placed to achieve the objects sought to be achieved by the legislation, Your Lordship. Stating this, the Council would like to first particularly substantiate that TAPA does not violate the right to bail, which is an offshoot of Article 21, due to the liberal interpretation of 21 by the judiciary, Your Lordship. Your Lordship, Section 43D5 of the Terrorist Activities Prevention Act places a restriction on the grant of bail for the accused under the Act. Your Lordship, the Section 43D5 reads, and I read verbatim, notwithstanding contained in the code, no person accused of an offence punishable under Chapters 4 and 6 of the Act, if in custody, be released on bail or on his own bond, unless the public prosecutor has been given an opportunity of being heard on the application of such release, Your Lordship. Your Lordship, in this provision, the power of the court to grant bail is not at all circumvented. It is not at all taken out, it is still intact. But Your Lordship, only a restriction has been placed that the public prosecutor has to be heard on the application of such release by the accused. Your Lordship, again substantiating intelligible differentia, it is well within the procedure, Your Lordship. Your Lordship, in the recent decision of the Apex Court in Zahur Ahmad Shah Watali versus Union of India, the Supreme Court held that the provisions of UAPA restricting the grant of bail were valid and constitutional. The court observed restrictions were necessary to ensure that the accused did not indulge in activities prejudicial to the security of the state, Your Lordship. Your Lordship, security of the state is very sensitive in nature, and the accused cannot be released on bail, and then we cannot cry over the spilled milk, Your Lordship.
So you
More,
mean to say that the judges, merely because they hear the public prosecutor,
yes, Your Lordship.
without hearing the public prosecutors, the judges have a closed mind and they open it only when the public prosecutor opens his mouth?
No, Your Lordship, it's just because the public prosecutor will be able to present the case of the government as to how they are detrimental to the society if they are released. And the prima facie evidence would be submitted as to how they're detrimental to the society and the integrity of the nation, Your Lordship, and that will be upheld by the court, Your Lordship. If Your Lordships are convinced. Moreover, the petitioners are contending that they want to seek anticipatory bail, Your Lordship. Your Lordship, the counsel would like to mention that the accused do not even pass the triple test of bail under ordinary criminal jurisprudence. The triple test of bail is that the first rule says the ascertainment of whether the accused is in an act or under the flight risk, Your Lordship. Your Lordship, accused such as Coleman Deadly can fly to whatever nation that accommodates him, which is accommodative of them, Your Lordship. Your Lordship, the second rule is that possibility of tampering with evidence. Your Lordship, again, the issue in this matter is very sensitive in nature, and evidence can be easily tampered with. And Your Lordship, the rule 3 says influencing witnesses, Your Lordship. Your Lordship, even if one rule of this is not checked by the accused, then they'll not be released on bail under even the ordinary criminal jurisprudence. And this is a departure from ordinary criminal jurisprudence, and this is for the serious offense of terrorism, Your Lordship.
That is precisely the arguments of petitioners, that you rope in anybody and you don't grant them bail because you say that they are not entitled to, because you assume, because there's a presumption.
Yes,
Whether that is precisely what is being challenged. So
Yes.
the judgment in Watali and Najib and thereafter also, this court has held that if they are able to make out a case and it's a rule of law, that generally bail is the rule and jail is an exception.
Yes, Your Lordship.
So you'll have to establish.
Yes, Your Lordship.
So isn't it, that's why they say it is draconian.
Yes, Your Lordship.
What do you say?
Your Lordship, for the same, Section 22 of NIA Act, special courts are established under the NIA Act, Your Lordship. Under this provision, every 30 days, an accused has to be brought before the court for remand, Your Lordship. Your Lordship, the public prosecutor will appear there as well and will establish their case as to how the prima facie evidence is there. And the court will decide as to how much of a remand the accused will be getting. If they establish the prima facie evidence, a further extension of 30 or 90 days will be provided by the court, after which they'll be again presented before the special sessions court, Your Lordship, where they'll be tried, Your Lordship. So there is always an opportunity for getting bail for the accused, and as the petitioner says, it's not circumvented at all, Your Lordship, and it's also open for judicial scrutiny, Your Lordship. Only a restriction has been placed. Your Lordship, if the Lordships are satisfied with the arguments, can the counsel,
Yes.
the co-counsel continue? It is indeed a pleasure arguing with the court.
The counsel seeks permission to proceed, Your Lordships. Much obliged. Your Lordship, the second part of issue 3 deals with whether Terrorist Activities Prevention Act violates Article 22 of the Indian Constitution. Your Lordship, I shall be dealing with this issue in a two-pronged approach, the first of which being review committees, and the second is the maximum period of detention under this act. Your Lordship, I would like to quote Your Lordship, I would like to quote Article 21, where it states that no person shall be deprived of his life and personal liberty except according to procedure established by law. Your Lordship, however, a person's personal liberty can be deprived if the procedure is according to law. Your Lordship, and it is in this aspect, Article 22 provides the procedural requirements which must be adopted and included in any law enacted by the legislature. Your Lordship, the Constitution itself permits the Parliament to make law for detention for a period of more than 3 months, and I kindly request the bench to refer to Article 22 of the Constitution. Your Lordship, if you can kindly refer to Clause 4 of Article 22, it states that no law providing for preventive detention shall authorize the detention of a person for a longer period than 3 months unless an advisory board is constituted. Your Lordship, a mere glance at Section 37A of the Terrorist Activities Prevention Act is enough to prove that it is in consonance with Article 32. Your Lordship, having said that, I would like to quote the case of A.K. Roy versus Union of India, where the Supreme Court, by 4:1 majority, upheld the constitutional validity of NSA, the National Security Act, which also had an advisory board in place. Your Lordship, it stated that the advisory board was neither vague nor arbitrary in its provisions, providing for detention of people under Article 22, Clause 4 of the Constitution. Your Lordship, having said that, I would like to guide the court to the next clause in the Parliament with regards to Article 22, which is Clause 7, Your Lordship. Under Clause 7, Lordship, under Clause 7, it is stated that the Parliament may prescribe the circumstances under which a person may be detained for a period longer than 3 months. It has already been established by the Council under Clause 4. But, Your Lordship, however, the subclause B states that the maximum period for which a person may be detained shall also be prescribed by the Parliament. Your Lordship, Section 37A of the Review Committee states that there shall be a period of 2 years for which a person shall be detained in preventive detention. Your Lordship, and I would like to rely just purely on the Constitution before going to the judicial precedents, that it is in consonance with Article 32, that is the procedure established by law. Your Lordship, having stated that, I would like to quote the case of Fagusha versus West Bengal, where Justice Bose declared that a law providing for detention of a person for beyond 3 months must either satisfy Clause 4, Subclause A, or Clause 4, Subclause B. But in the case of TAPA, Your Lordship, both subclauses are satisfied.
But you have to establish that is a subjective satisfaction of the authority to detain a person in a preventive detention matter.
Yes, Your Lordship,
That
I
you
will
have to
be
prove.
addressing it in my subsequent arguments. Your Lordship, the grounds in order to satisfy the code is that the requirements are in the accused should not act in a manner which is prejudicial to the defense of India, security of India, and security of the state. And hence, these are very reasonable grounds due to which the court should uphold the validity of this section. Your Lordship, I would like to state the fact that my esteemed co-counsels on the counsels on the other side are stated about people languishing in jails because of Section 37 of the review committees. Your Lordship, that is why in 2021, if you can refer to page 2, para 4 of the Moot proposition, the 2020 amendment brings in 37A in order to establish a maximum period of detention of 2 years. Your Lordship, hence, there is a 2-year provision which is now in place. People cannot be languishing in jail for a period of more than 9 years hereafter. And hence, the amendment only aims to protect the people and not discriminate people or detain them for an unnecessary long period. Hence, any contention of the petitioner in that regard is rebutted by the respondent, Your Lordship. Your Lordship, having stated that, I would like to move on to my next issue of the
Do you
bench.
mean to say that liberty, if there's incarceration for 2 years, liberty is preserved?
No, Your Lordship. In that context, I would like to
Even
bring...
a day's
Definitely.
detention will be in a violation of Article 21 if it is not done properly.
Definitely, Your
In accordance
Lordship.
with law, isn't it?
Definitely, Your Lordship. That is why there is one more safeguard, Your Lordship. As my co-counsel had established, the Section 22 of NIA Act 2008 discusses about the Section 22 of NIA Act 2008 discusses about special courts. Your Lordship, under this section of the NIA Act, the accused is subjected to the presence in front of a magistrate under special session court, where he has to be produced before a magistrate, and the magistrate shall take a decision as to his detention. He shall see if the investigation or the proceedings are going on par with further evidence which is produced, and if he is satisfied, only then he shall extend the period of 30 days, Your Lordship. And in these 2 years, the accused is repeatedly being produced before a magistrate. And hence, if in case the prosecution is not able to prove that the investigation is not sufficient or something, the magistrate will immediately dismiss the case, and within 2 years, the justice shall be meted out to the accused. And Your Lordship, 2 years is just a maximum time limit. And before this, the court has the power to acquit. Your Lordship, may I move on to my next issue? Your Lordship, the next issue is whether Terrorist Activities Prevention Act 1967 violates Article 20, Clause 3 of the Constitution. Your Lordship, I shall be dealing with this issue in a three-pronged approach, the first of which being 43G does not meet the threshold of Article 20, Clause 3. Your Lordship, for attracting 20, Clause 3, there must be three ingredients which must be established. Your Lordship, firstly, the person should be accused of an offence. Secondly, the compulsion should be against the person should be compelled to make a statement, and thirdly, the compulsion should be against himself. Your Lordship, even if one of these ingredients is not satisfied, it shall not meet the threshold of Article 20, Clause 3, Your Lordship. And I will be establishing that 43G does not meet the requirements of 20, Clause 3 by stating the 11-judge constitutional bench verdict in Katikalu Ogad, State of Bombay versus Katikalu Ogad. Your Lordship, with reference to ingredient 2, which states that a person should be compelled to make a statement, and I would like to quote the same case where the court held an accused person cannot be said to have been compelled simply because he made a statement while in police custody without anything more. Your Lordship, with a mere asking or directing a person to do something does not amount to compulsion under Article 20, Clause 3, and it has been upheld by this court in Mohammed Dastagir versus State of Madras. Your Lordship, having stated that, I would like to counter the third condition. The third condition states that such a compulsion should be against the person himself. Your Lordship, in this regard, compulsion is an essential ingredient, but if a person makes a confession without making inducement, threat or promise, it is being considered by the court that he has waived off his right under Article 20, Clause 3, Your Lordship. Again, the council would like to rely on a string of cases, including Nandini Satpathy, Katikalu Ogad, Mohammed Dastagir, where the Indian judiciary has repeatedly upheld the fact that Article 20, Clause 3 can be waived off if the accused produces a document which is incriminatory in nature or gives an oral statement which is
Judgment
incriminatory.
relating to Katikalu is relating to 20, Clause 3,
Yes, Your Lord.
self-incrimination,
Yes, Your Lordship.
not related to this point actually.
Your Lordship?
Not related to this point actually.
Okay, Your Lordship.
That is only in for self-incrimination.
Yes, Your
How
Lordship.
can the person can give evidence against his own?
Yes, Your Lordship. Your Lordship, 43G of the TAPA discusses that confessions can be recorded, Your Lordship. It is in response to this the council is stating it does not meet the requirements of 20, Clause 3. 43G of the TAPA, Your Lordship.
What does 43G say?
1 minute, Your Lordship. I'm taking the proposition.
Talking about 43D or G?
G, Your Lordship. It is present in the Moot proposition. Page number 2. Para 2. Yes, Your Lordship. 43G of TAPA states that certain confession made to police officers can be taken into consideration.
What do you say with regard to extrajudicial confessions and validity and veracity?
Yes, Your Lordship.
And what is that? What
Your
do you have
Lordship,
to say on
that
that?
is my next sub-issue, Your Lordship.
Yes.
I shall be discussing it. Your Lordship, before I move on to it, I have one small point I would like to make under this issue. Your Lordship, with regard to search and seizures under TAPA, in Kuttan Pillai vs. Ramakrishnan, the court held that the search of premises occupied or seizure of documents is not violative of Article 20, Clause 3. And Your Lordship, with reference to Section 43F, which imposes legal penalties on not answering truthfully, it has been held in the case of Nandini Satpathy and C. Sampath Kumar vs. Enforcement Directorate that it does not fall under the purview of Section 20, Clause 3. Your Lordship, with regards to your question, I shall be establishing it in my second sub-issue, which is Section 43 has adequate safeguards. Your Lordship, Section 43G of the TAPA imposes certain very strict conditions on the police officer with regards to recording confessions. Your Lordship, firstly, the first safeguard can be found in section 43G, subsection 1, where it requires the police officer to explain to the person making the statement that he is not bound to make a confession, but if in case he makes a confession, it shall be admitted into evidence. Your Lordship, the respondents would like to rely on the landmark judgment of D.K. Basu, where the court held the fact that if an accused makes a confession, even after he's been informed that he's not required to make a confession, then it should be admitted into evidence, Your Lordship. Your Lordship, the second safeguard under 43G can be found in the second subsection of 43G. It is where
the case of petitioners is the extrajudicial confessions. Of course, nobody will say in the act that you need not make, of course that is there.
Yes,
but
sir.
their case is that you are going to be coerced and forced to make such confessions. What is the validity of such confessions under the act? Whereas under the other provisions, it's not valid.
Yes, Your Lordship. Your Lordship, I would like to defend the validity of this section in this regard by quoting the judgment of Kartar Singh. In Your Lordship, in Kartar Singh, it was held that if recording of confession by police is found to be necessary by the Parliament, and if it is in tune with scheme of law, then it is for sure illegal. Your Lordship, the court may wonder as to why the council. Your Lordship, the court may wonder as to why the council is taking up the case of Kartar Singh, which the government has repealed in Tada. Your Lordship, but in Kartar Singh, the same section of section 15 of Tada is very similar to section 43G of TAPA. And while deciding on Tada, the court had upheld several guidelines. It had stated that recording of confession by the police shall be held in law if there are adequate safeguards. And Your Lordship, the legislature, while passing this law, had taken into the considerations which was mentioned in Kartar Singh, the guidelines which the court laid down, the 11-point guideline which the court laid down in Kartar Singh. Your Lordship, you can refer to para 263 of the Kartar Singh judgment. Your Lordship, the Parliament, having taken considerations of the same guidelines, has only established this, Your Lordship. And hence, we would like to contend that police confessions is admissible under section 43G of the TAPA. And it falls within 20.
How do you sanctify that the confessions rendered before the police of a particular rank is correct and should be taken as gospel truth and he is not in collusion?
Your Lordship, with regards to that question, Your Lordship, we do not compel the accused, Your Lordship. We are not going to, if in case of questioning, if he gives out a confession, we shall simply produce it before the magistrate. And Your Lordship, there exists a safeguard here also. The magistrate can test the veracity of the confession which is made. And it depends on the facts and circumstances of the case, Your Lordship. If the magistrate is not satisfied that the confession was extracted in a reliable manner, then it can be dismissed of evidence, Your Lordship. Your Lordship, relying on the Justice Malimat Committee, it is stated that the accused is the bigger source of information. Your Lordship, you can bring in evidences, you can bring in witnesses and all of it, but the accused only knows what has happened in the case, and I would like to state that if the extrajudicial confession is voluntary and true, and it is reliable and trustworthy, the magistrate can take it into account.
But one must look into the compelling circumstances.
Yes, Your Lordship.
Compelling circumstances to give evidence against himself.
Your Lordship, can you repeat the question?
The compelling circumstances, insofar as the admissibility of the evidence is concerned,
Yes, Your Lordship.
that makes a lot of difference insofar as draw the inference in a particular case.
Yes, Your Lordship. Your Lordship, the petitioner have not made contentions, but this can be found in section 25 of the Evidence Act, Your Lordship, that confession to a police officer shall not be admissible in court. But Your Lordship, there exists section 27 of the Evidence Act which provides exceptions to 25. Section 27, if you can look into the Bar Act of Evidence Act, it states that confessions to a police officer can be taken into consideration, and by upholding section 27, which is an exception to 25, the respondents would like to submit that it shall be taken into evidence. Much obliged, Your Lordship. Your Lordship, may I move on to my next issue? Your Lordship, issue number 5 is whether Terrorist Activities Prevention Act violates international obligations. Your Lordship, I shall be dealing with this issue in a two-pronged approach, the first of which being the position of the Indian Constitution with regards to international obligation. Your Lordship, Article 253 of the Constitution states that a treaty entered into by India cannot become a law of the land unless it is implemented by the Parliament under 253. The Constitution itself clarifies that for implementing any treaty obligations, a law has to be passed by the legislature. Your Lordship, I would like to rely on the case of State of West Bengal versus Kesram Industries, but the 5-judge constitutional bench held that it is true that the doctrine of monism does not prevail in India as in US and Europe, but it is the dualist structure which is found in courts of India. Your Lordship, having stated that treaty making and implementation of treaties is a subject of union legislation, and the power to legislate in respect of treaties lies with the Parliament under entries 10 and 14 of List 1 of the Constitution. Your Lordship, the Supreme Court, in a very recent decision in 2014, National Legal Services Authority versus Union of India, while interpreting Article 51 and 253, held that if Parliament has made any legislation which is in conflict with international law, municipal law should prevail. Your Lordship, if you can refer to page number 28 to 31, the Council for Respondents have made extensive research with regards to it. We have provided a number of binding case laws which states that international law shall not be binding in Indian courts, and that will be my next sub-issue, which is the enforceability of such obligations in Indian courts. Your Lordship, in Xavier versus Canara Bank Limited, the issue pertained as to whether international treaties can become a part of corpus juris in India, Your Lordship. And the court specifically held that breaches for remedy in international law is not found in the domestic courts of the state. Your Lordship, international law does not have the force or authority of civil law, was the ratio of this case in Xavier versus Canara Bank Limited. Your Lordship, having stated that, I would like the court to refer to page number 31. Page number 31 of the memo, wherein Gramophone Company of India Limited versus Birendra Bahadur Pandey, the court, while discussing doctrine of incorporation, recognized that rules of international law are considered to be a part of national law unless they are in conflict with Act of Parliament. Your Lordship, the court sternly held that committee of, this is a very interesting observation, Your Lordship, the court sternly held that committee of nations or no, municipal law must prevail in case of conflict, and if Parliament has said no to a principle of international law, national courts cannot say yes. Yes, Your
Mr.
Lordship.
Counsel, are you aware that India is a signatory to this Committee of Courts of United Nations?
Yes, Your Lordship, it is.
So when India is a signatory, how can you say that they cannot be bound by the signatory, which is signatory to the agreement of Committee of Courts?
Your Lordship, in this context, I would like to quote that even the UN, in its report, has admitted that there is a flaw in international obligation, that even the UN cannot enforce obligations on a specific country when it has a domestic law in place. The UN report has still admitted this is a defect, and even the UN today is discussing to bring a provision by which they can enforce all the countries to implement it in their domestic law.
No, that's precisely why the signatory of this Committee of Court is signed by several nations, because now world is in the tips of fingers. People are moving from one country to the other country.
Yes, Your Lordship.
So when, for example, in the cases of matrimonial cases of divorce where there is an agreement signed, the Hindus may not be coming within the parameters of laws of United Nations or Australia or anywhere. So that's why this Committee of Courts is signed, and India is an agreement hold up to that.
Yes, Your Lordship.
So you are bound by that agreement and you have to enforce it.
Your Lordship, but if in case there is a municipal law prevalent, Your Lordship, only the domestic country knows the problems and issue which is taking part in the country. Your Lordship, these international obligations have been signed 30 years back, 40 years back in time, and today in modern context, the issues of terrorism are developing. There are new things which are happening in the country, new forms of terrorism which are taking place in the country, and these cannot be dealt by international obligations which have been ratified over a period of 40 years, Your Lordship. And in presence of in case of the modern changing situation, it is established that international obligations, even though ratified, do not have a binding force on the country. Your Lordship, I have one last submission to make with regards to presumption of guilt. Your Lordship, this sub-issue, I would like to I'd request the court to take it into record under Article 20, Clause 3 issue of the Council. Your Lordship, the Council for Petitioners has stated that Your Lordship, 43E of TAPA presumes guilt on the accused. Your Lordship, if you can kindly refer to 43E. It states to presumption as to offences. Your Lordship, the law in certain exceptional circumstances can presume the guilt of the accused. Your Lordship, this is done in large interests of the society and to meet ends of justice. Your Lordship, I would like to quote the case of Noor Aga Khan versus State of Punjab, where the court held that presumption of guilt arises only when the prosecution proves certain foundational facts. And only after this the burden is shifted on the accused. Your Lordship, even in the case of Section 43E, it does not take away the primary duty of the prosecution to establish the foundations of the case, the primary facts. And only after this, the burden is shifted on the accused, Your Lordship. Hence, the primary burden of proof exists on the prosecution and not on the accused. Your Lordship, furthermore, the section has also built adequate safeguards. Section 43E has built adequate safeguard to prevent misuse and misapplication of this provision. Your Lordship, if you can refer to subsection A and subsection B, it states...
Again, look at 43E. Please look at 43E.
Yes, Your Lordship.
Merely because, supposing, I go onto the plane. Somebody says that, look, my relative is there in UAE, you are going to UAE, please carry it for her or
Yes.
him. And there's a bomb inside. There's a presumption that he is guilty. I am not used the bomb. I'm just a carrier, not knowing what it is. I'm totally innocent. What happens? Please
Yes.
look at the section now.
Your Lordship, this is where Section 15 comes into play, Your Lordship. Section 43 is not merely interpreted. In order to interpret Section 43, the court has to look into Section 15. Section 15 brings in the element of mens rea. Your Lordship, because Your Lordship, Section 43 only discusses about the presumption of offence, Your Lordship, whereas Section 51 clearly classifies the mens rea which is required. And hence, Your Lordship, Section 43 has to be read with Section 15 of the TAPA. It is not a separate provision of its own.
What my brother said was that when there is a presumption, you cannot say that the prosecution is, that's the reason why the presumption is made in any enactment. When there is a presumption that you are the accused or guilty, you have to rebut that presumption.
Yes, Your Lord.
So the example put forth, how do you answer such a presumption?
Your Lordship, can you repeat the question?
That when there is a presumption, you have to rebut the presumption. The question of prosecution proving does not arise.
Your Lordship, the prosecution firstly establishes the foundational facts, Your Lordship. It states that this is the so-and-so reason is why the accused has been prosecuted under TAPA, and the prosecution also establishes under what offence it falls under Section 15. Yes, Your Lordship. It classifies Section 15 because, Your Lordship, Section 15 is the base. It is the base on which all other provisions are enacted, and before a presumption is made, Your Lordship, if you can refer to 43E, it states presumption as to offences under Section 15. It is the first line. And Your Lordship, without taking 15 into consideration, this section cannot even exist, Your Lordship. And hence the element of mens rea, as a question by the respectful judge, it is answered in Section 15 of the Terrorist Activities Prevention Act, Your Lordship. Your Lordship, may I please move on to our prayer? Yes, sure. Oh, much obliged. Wherefore, in the lights of facts stated, issues raised, arguments advanced, and authority cited, it is most humbly prayed before this honourable court that it may be pleased to grant and declare that all the instant petitions are not maintainable and therefore have to be duly dismissed. It is also humbly prayed before this court that it may pass any other order, direction, or relief that it may deem fit in the light of justice, equity, and good conscience, all of which is humbly prayed. Counsel for the respondents, RNMC 020. It was indeed a pleasure arguing before this honourable bench. Thank you.
Thank you.
Counsel seeks permission to approach the bench for
Yes.
Lordships, to be noted, Your Lordships, we have not challenged the validity of the Act but certain sections, your lordships. And if there are certain provisions which are restricting, your lordships, but what we want is certain safeguards which the Council for the Respondents have failed to assure us with, your lordships. And, your lordships, the Council for the Respondents have failed to mention why individuals are classified into two types. They have presumed our problem is classifying individuals and organizations. That is not the issue of the petitioners. The issue is why individuals are classified into two types, where one has rights and mechanisms, where one doesn't. That is the issue of the petitioners, which the respondents have not cleared, your lordships. And, your lordships, the vague provision of section 15, which the Council for the Petitioners mentioned, was likely to induce terror, your lordships, or with intent to cause terror, your lordships. The word terror was vague, is what the Council for the Petitioners had contended. But the Council for the Respondents have given a different analysis on a different term, which is any other means or whatever nature. The Council for the Petitioners are not contending that. The Council for the Petitioners are asking for the overbroad meaning of the word terror, your lordships, which hasn't been defined. And, your lordships, terrorism is a grievous offence, as all of us know, but it has not been defined itself in the Act, your lordships, which is a grave offence and thus needs to be mentioned, your lordships. And, your lordships, we are challenging the constitutional validity of certain provisions. And, your lordships, section 2, clause O.
Then doctrine of severability has to be applicable.
Yes, your lordships. Your lordships, moving on to the next point, your lordships, section 2, clause O and section 124A, we established a point where they are very similar to each other, your lordships. And the Council for the Respondents have failed to tell us why they are both similar, which is just making another provision for the government to rope in the citizens, your lordships, when especially sedition has been put on hold in the country, your lordships. And, your lordships, we never said that individuals should not be included in the Act. We understand individuals need to be included. We are asking the intelligible differentia of why individuals are classified into two types, your lordships. And as your lordships had noted, the Council for the Respondents had relied on ADM Jabalpur case for Article 21, your lordships, which has been clearly overruled in the Puttaswamy case, your lordships. And, your lordship, mere belief over here of the government is enough to rope in anybody, your lordships. And where an act is, and thus makes the act arbitrary, your lordships, which is mentioned in the E.P. Royappa case, your lordships. And in the case of State of CBI versus Amar Tripathi, there are 8 conditions of bail, but the only point which is required over here in section 43D5 is only prima facie case is necessary. What about the other 7 conditions which is required to grant bail, your lordships? Moving on, your lordships, we know it's a preventive retention law, 180 days is required, your lordships. But when a stringent provision like that is there, what are the safeguards which are given to us, your lordships? The belief is the only criteria which they are contesting on, your lordships, which leads to a lot of malicious prosecution in the country, your lordships. And not just that, it says when there are stringent bail provisions in the country, a speedy trial should take place. How is this justifying the speedy trial, your lordships? And this has also been laid down in the Shaheen welfare case. And, your lordships, what is the liability of the government if unwanted trials are acquitted? And, your lordships, the Council for the Respondents also mentioned a period of 2 or 9 years, your lordship, for keeping a person incarcerated. But as I mentioned, the Adambai, Sulambai, Ajmeri versus others and versus state of Gujarat, 6 people were acquitted after 10 years of incarceration, your lordship. 10 years is not a small time for someone to spend in jail, your lordships. And, your lordships, no classification with regards to section 18, section 20 and section 38 was given, your lordships. And, your lordships, the Council for the Petitioners had no problem with the seize and search and seizure as mentioned in the Act, your lordships. And, your lordships, they repealed, they had said that 43G has provisions which is mentioned under Pota and Tada. But the proposition fails to tell us what are the safeguards which has been given under section 43G, your lordships. There are no safeguards which has been given. And it is known that police have been known for their malicious act, your lordships. And there have been number of cases. And what do you know? That the police will take confessions after informing them you have to tell that whatever confessions said by them is going to be used against them. This is vague, your lordships. And also the Malimat committee report, which the respondents had focused on, gave recommendations on adversarial criminal justice, Your Lordship, justice system, which is exactly what the counsel for the petitioners are challenging, Your Lordships. And Your Lordships, counsel requires 30 seconds to finish, Your Lordship. And the counsel for the respondents had relied on the case of Xavier versus Canara Bank regarding international agreements, which is a case dealt by the Kerala Tribunal, Your Lordships, and it only has persuasive value and is not binding on this court. And to note, Article 253 of the Indian Constitution allows international constitutions, Your Lordships, and the TAPA has been made on the basis of recommendations of many international organizations, Your Lordships. And this is what we are, and this is why what we are contending, Your Lordships. The counsel rests her arguments, Your Lordship.
Yes.
Your Lordships, the petitioners had first contended the intelligible differentia, which was very well established by me in my arguments. And Your Lordship, unequals can never be treated equally, and that is why individuals are categorized into two types as to how they are accused of terrorism and this grotesque offense of terrorism under this particular legislation, and that is why they are categorized in that aspect. And Your Lordship, as Your Lordship mentioned, doctrine of severability only should be applied where you're contending particular provisions of the Act, and you cannot invalidate the whole Act, Your Lordship. Your Lordship, the petitioner also contended 43G.
That means you are willing to.
No, Your Lordship, there is no unconstitutional provision in the Act at all. But if in case the petitioner
Are you conceding?
Your Lordship?
Are you conceding for setting aside a certain provisions as unconstitutional?
Not at all, Your Lordship.
Then you said so.
So just in case such a situation arises, it has to be applied with doctrine of severability, and the whole legislation intact is constitutional, Your Lordship. Your Lordship, the petitioners had also contended 43G. Your Lordship, the co-counsel had dealt with it in further ponderance, and he had bifurcated every issue into that and dealt with 43G, Your Lordship, and it requires no clarification. And regarding the Xavier case, in the same issue, Your Lordship, in the Moot proposition, binding cases are also put forth, and for the Lordship's reference, Your Lordship. Thank you.